broadcasting from the Unshackled Studios in Melbourne. This is WilmsFront, brought to you by theunshackled.net. Now here's Tim Wilms.
Hello and welcome to tonight's show. The date is Wednesday the 13th of November 2019. It is 7:30 p.m. here in Melbourne. There was a half an hour delay tonight, basically because I arrived back from the County Court of Victoria at the studio just 2 hours ago, and I've been frantically preparing for tonight's show. As the expression goes, better late than never. We are live on the Tim Wilms YouTube channel and also live on Entropy, which is the YouTube enhanced software, which allows you to ask me questions throughout the show. And also, best of all, you can send through a super chat through the donations section, which more goes directly to the Unshackled, none goes to Google, and less of a cut goes to Entropy, the great creators of this software. And if I feel like it, I can also do a poll. So I'll just put the link in there as well. As you can see, obviously, my voice has had a bit, I'm probably a bit aching all over just because, yeah, it's been to and from the city early mornings and then, yeah, late at night bringing you the shows as well. But yes, in case any of you weren't aware, I was at the County Court of Victoria, not just today, but all of this week, covering Blair Cottrell's blasphemy appeal trial, which began on Monday. I spoke a bit about it last night on Trans-Tasman Talk with my New Zealand counterpart, Dewey DeBoer of Right Minds. Now, the presiding judge in this case is the Chief Judge of the County Court, Peter Kidd, and it's interesting that he was the judge who presided over Cardinal George Pell's two trials on historical sexual abuse of two choir boys in 1996. Because there were two trials, the first one resulted in a hung jury. The second one unanimously found George Pell guilty, and Chief Judge Kidd, he sentenced Pell to 6 years in prison for those offences. Cardinal Pell appealed to Victoria's Court of Appeal. 2-1 they upheld Pell's conviction. The dissenting judge, Weinberg, said that the conviction should be quashed. But it just broke today, just as I was about to go into the court, that the High Court of Australia had agreed to hear arguments for and against his conviction from both the Victorian DPP and Cardinal Pell's legal team. It's not special leave to appeal. They're going to decide, the High Court, both whether he'll be granted leave to appeal, and if they accept the appeal. Is a bit complicated by that. But yes, as I said, the trial began on Monday, the 11th of November, which of course was Remembrance Day, lest we forget. It's probably not as big in Australia as Anzac Day, because Remembrance Day, of course, remembers the armistice in the end of World War I. The first Remembrance Day was November the 11th, 1919. So it's the 100th anniversary of the first Remembrance Day, but obviously 101 years since the end of the First World War. But for those of you who have read your history, you will know that the Treaty of Versailles at the end of the First World War, that sowed the seeds for the Second World War. So even though we're remembering the armistice, supposed to be the end, war to end all wars, it didn't turn out like that. But I digress from the actual point of Remembrance Day, which is remember the fallen soldiers, no matter what war they fought in or for what cause. Just recognize their service to our country, and also just the sacrifice they made in general, because you have to be very brave, courageous, disciplined to serve in the military, let alone on the front line in war. So I thought I'd just make that point. And now I will share with you, because I did a number of vlogs outside the court, I will first share with you my opening remarks on the first day of the trial on Monday.
WilmsFront, brought to you by theunshackled.net.
We're here today on the 11th of November 2019 at the County Court of Victoria to hear patriot activist Blair Cottrell's appeal trial against his 2017 blasphemy conviction under Victoria's Racial and Religious Tolerance Act 2002. He was charged for performing and uploading to Facebook a mock beheading of a dummy outside the Bendigo Council during the construction of a mosque. It was during the United Patriots Front activism in the city during 2015. The Magistrates Court trial took place in September 2017. The three of them, there were, as they were known, the Bendigo Three, Blair Cottrell, Neil Erikson and Christopher Shortis. They were found guilty. Blair Cottrell had a conviction recorded against him and they were fined $2,000 each. And that was for inciting serious contempt, ridicule and revulsion against Muslims. Blair decided to appeal his conviction and employed the services of patriot lawyer John Bolton. They were originally challenging the conviction on the grounds that Victoria's Racial and Religious Tolerance Act is constitutionally invalid under Australia's implied right to freedom of political communication. Given that it was a matter of constitutional law, they directed first to lodge an appeal with the High Court of Australia. In December 2018, the High Court directed John Bolton and Blair Cottrell to go back to the County Court of Victoria to lodge their appeal. The High Court would not hear the case until all other avenues of appeal had been exhausted by either side. In June this year, Victorian Attorney General Jill Hennessy joined the Director of Public Prosecutions in the appeal proceedings. This was due to the government's belief that defending the validity of the Racial and Religious Tolerance Act was necessary to protect all laws against hate speech and to safeguard community cohesion. But then the Victorian government admitted that Cottrell's conviction under the Racial and Religious Tolerance Act might conflict with its own Charter of Human Rights and Responsibilities, specifically the human right to freedom of expression and the freedom of political discourse. The appeal trial was originally set to take place on August the 12th. However, the original trial judge, Lisa Hannon, could not hear the case as scheduled as she accepted a new appointment as Chief Magistrate of the Magistrates Court of Victoria. A rescheduled trial is now taking place on Monday today. It is being heard by the Chief Judge of the County Court of Victoria, Peter Kidd. Blair himself will be giving evidence and will also be cross-examined. The legal process is always slow, but we are finally at the trial. Depending on the verdict, this trial might be only the beginning of this legal battle over free speech.
This is WilmsFront, brought to you by theunshackled.net.
So there you go, that was my opening remarks. Now, just to elaborate a bit more, the Racial and Religious Tolerance Act, it's 2001, not 2002. I was off by a year. But just giving you a background on, there will be a number of people who remember the United Patriots Front, which is basically defunct now. It became most known in the media for its activism against the proposal to construct a mosque in Bendigo, where, according to the United Patriots Front and concerned residents of Bendigo, there was only 36 practicing Muslims in Bendigo, but the mosque and its associated amenities outside would have been able to house 2,000 people, so basically turned it into an Islamic hub. In their view, the mosque only broke ground this year, back in July 2019, and Daniel Andrews, he dug the first shovel into the dirt and gave the mosque $400,000 of Victorian taxpayers' money, and he also was of the view that bigotry was not an acceptable form of protest, which was obviously directed at the Bendigo faithful, who they are the local Bendigo residents who they were present during the United Patriots Front rallies in 2015, and every Thursday they hold a patriot demonstration, or what do you call it, celebration, in the Bendigo City Centre. It's at noon every Thursday, obviously supporting free speech, patriotism, and obviously opposing the influence of Islam. All of them travelled down from Bendigo to support Blair and sit in the gallery. And this brings me, because Blair was keeping his followers on Gab updated, and this happened on the first day of the trial. There was this is from Associated Press. The title here says far right mock beheading video played in court. It's alleged that supporters of far right Blair Cottrell were seen laughing and clapping when the video was played, and of course I was there. They did clap because they played one of Blair's subsequent vlogs about the beheading, and they clapped at Blair's vlog, not at the actual beheading. So that is an important distinction there. And Judge Peter Kidd said at the time, "Quiet, please." And then when the court adjourned, just did a general thing. I expect this court to be conducted in silence. So that article from Associated Press, it was pretty much a big nothing burger. The author of that article was Georgie Moore. She was in the court that day. But yes, I will go to Blair's second Gab post. No, this is from Tuesday. So this is when he took the stand, because it adjourned at midday and then resumed the next day. They heard from the court heard from the original police informant, and this is just Blair commenting on his cross examination. So they've got to prove intent, that he deliberately set out to incite negative feelings in people about the whole Muslim community. And obviously, because it was published to Facebook, there were a lot of comments there. Anyone who's on Facebook will know that a lot of the comments are strong. And so Blair says here his own barrister, which is John Bolton. Obviously, Blair had been active for about 6 months before this mock beheading video was filmed and published. Blair maintains that his opposition to the mosque was opposing the state and media powers, not to incite hate merely for the sake of doing so, or against Muslims. And Blair makes the point here that the state prosecution, what he means there is that there was the director of public prosecution, legal counsel, and their legal assistant, and then the representatives from the State Attorney General's office. And this talks about that what comes next was the constitutional invalidity of the law. That's not what happened that afternoon. They were hearing about the Victorian Charter of Human Rights and Responsibilities. Now just go to update 3. I'll play my update now at the end of day 2. And then I'll show the rest of Blair's Gabs there.
Is WilmsFront, brought to you by theunshackled.net.
So day 2 of Blair Cottrell's appeal trial over his conviction under Section 25(2) of Victoria's Racial and Religious Tolerance Act has wrapped up. So basically what we've heard so far is the evidence of the case to convict him. So that's basically looking at the original Facebook video of the mock beheading and the additional marching and promotional footage afterwards. Blair Cottrell took the stand himself. He was examined by his lawyer, John Bolton, then cross-examined by the DPP prosecutor, and then re-examined. Basically what it all boils down to is what the prosecution is trying to prove, that Blair Cottrell's intent was to incite revulsion, ridicule and serious contempt for Muslims as a class of people. It all comes down to intent in this specific section. So we heard the closing remarks this afternoon by the DPP prosecutor, and we also heard from a representative of the Attorney General's department, basically saying that it's not just they're not just challenging this, Blair Cottrell and John Bolton, on the evidence itself, but also based on the Victorian Charter of Human Rights and Responsibilities 2006. So the State Attorney General's representative talked about how in enacting the Racial and Religious Tolerance Act 2002, it was only meant to apply to the most extreme contemptuous forms of vilification to incite hatred, and that the Charter of Human Rights and Responsibilities, although it guarantees freedom of expression, it has to balance out the freedom from harassment and intimidation and vilification. So the Charter of Human Rights and Responsibilities is, as you described, is basically about a balancing act. It's about to rain here outside the county court. This is day 2. Day 3 tomorrow will be John Bolton making his closing arguments, and then it will get on to the constitutional case. So there still could be at least a day, or maybe another 2 days. But that's it for today. I'll keep you updated.
This is WilmsFront, brought to you by theunshackled.net.
Now, you will have just noticed, as I did when I was watching back, my lips and voice weren't completely in sync. That's because I'm playing a high-quality video at the same time while I'm streaming this, so the computer is working overtime. I will upload these vlogs separately on the Unshackled main channel, so they'll be more easily digestible. People won't have to delve into this episode if they don't want to, but I would suggest, obviously, it's beneficial to watch this episode as a whole, basically, because I'm giving context to all of this, and of course going over Blair's own analysis. So I was going to go to his next gab here. This is what he said yesterday, that Racial and Religious Tolerance Act was introduced into Australia to disguise its real purpose. Diversity strengthens Australia. That's what I heard repeatedly throughout the state prosecutor and the representative from the Attorney General, that it's decided that multiculturalism in Australia is to be accepted, like it or not. So Blair's quoted as, diversity strengthens Australia. Australia is made strong by its multicultural society. It is interesting laid out plainly in the legislation which was read out today during the prosecutions. The primary method of application was not legal but educational. This means the act was primarily as legal protection for a vilified person basis for socio-political propaganda to be consumed by all persons. Education doesn't mean school, it means television, other forms of entertainment as an ongoing adult education. I'll elaborate more on this later. Now, obviously, the effects of legislation do filter through society, but it's definitely the law speaks for itself, that it's to limit vilification, and I'll elaborate on this further. I'll just go to Blair's next scab. So this is again from yesterday, and again Blair's talking about the Racial and Religious Tolerance Act. And this is the reason why I titled this episode free speech on trial, because it's not, because Australia doesn't have a right to free speech. This law limits the right of free speech in a trying to, obviously everyone says they support free speech, but so Blair goes into here about diversity quotas, refugee programs, speed limit on the street. In the same way you can disagree with multiculturalism, but taking steps to prevent it is not just controversial, it's illegal. Oh, well, I'm not sure what Blair means like that. Something I never knew, that, and I'm willing to bet that most tax-paying Australians never knew, that either the unnamed legislature introduced a bill, they had the audacity, what they call community need. It makes even more amusing, more ridiculous when the pro-multicultural activists call for the destruction of the state, where the state is literally based on the principles that are invested in themselves. It reminds me of that in the UK recently. You would all be aware now of the comeback of Mark Collett, who was originally a British National Party campaigner and youth leader. He gained a lot of publicity in 2002 when he was the subject of a Channel 4 documentary, Young, Nazi and Proud, and Russell Brand did a documentary on him which was titled Nazi Boy. So Mark Collett is back. He's launched a new nationalist organisation called Patriotic Alternative, and he produces a weekly show called Patriotic Review Weekly. Now, Mark Collett has... I'll just bring up the name of the producer of this documentary. If I can, Laura Towler. She's produced this documentary, We Were Never Us, where she interviews ordinary Brits, basically talking to them about mass migration and multiculturalism. And it's interesting that it's basically given that Australia is a multicultural nation, but who decided this? Were the Australian people asked? Honestly, there was never a vote on it, and of course we saw what happened when Fraser Anning, during his maiden speech, called for a referendum on the future of immigration to Australia. And of course what attracted most people's attention is that he called a public vote a final solution, which basically began the start of his tenure as national pariah. But yes, that was all on Tuesday. I'll just bring up Blair's... and this is all about it got really down into the constitutional... whether the Racial and Religious Tolerance Act is invalid under the Constitution, under the implied right to freedom of political communication. Blair was not allowed to give evidence in that case but there was a expert who gave evidence later that afternoon, basically talked about how religion is becoming more intertwined with racial identity, that they're sort of becoming the same, which was something that's new to me, because of course we know that there are Christians of heaps of different races. I mean, for example, a lot of the Chinese Australians, they're Christians, and of course Muslims are not just Arabic. There's also Slavic Muslims in Bosnia Herzegovina. There's Muslims just to the north of us in Indonesia and Malaysia. So in my opinion, certainly you would only say that religion and race are basically in unison when it comes to Jewish identity and practice, basically, because to be a practicing Jew, you have to be born a Jew. That's the only basically where there is a strict correlation with race and religion. And yes, this is Blair's final gab, finished for the day. This is today. John, as his lawyer John Bolton has concluded his because John Bolton is challenging on three. There's three challenges. They decided in the end, Blair Cottrell and John Bolton, to challenge the guilty verdict and conviction itself under Section 25(2) of the Racial and Religious Tolerance Act, also under the Victorian Charter of Human Rights and Responsibilities, and under Australia's implied right to freedom of political communication. So it got bogged down in quite a lot of case law, but it was quite informative, basically learning about how a legal process works, and also, basically, as the title suggests, we don't have free speech in Australia. So I caught up with Blair at the end of today, interviewed him. Hopefully when I play this, well, you'll hear the audio clearly, but our lips might not be in sync. But let's see how it goes.
This is WilmsFront, brought to you by theunshackled.net.
We've just concluded day 3 of Blair Cottrell's appeal trial against his conviction under Section 25(2) of Victoria's Racial and Religious Tolerance Act. That is for inciting revulsion, ridicule and serious contempt for Muslims. This was the mock beheading stunt that the United Patriots Front performed outside the Bendigo City Council in 2015. Now, this case has been talked a lot about the free speech implications for Australia, but I've been observing this case for 3 days now, and there is no right to free speech in Australia. We have what's called an implied right to political communication, which is actually not a personal right. It's a restriction on legislation so that it does not burden that freedom of political communication. So free speech in Australia, it doesn't exist, and it's not actually on trial here. This is a question of whether Blair had the intent to incite a whole class of persons in Muslims and whether he was engaged in political communication. His lawyer, John Bolton, has just wrapped up his closing arguments. I've got Blair here with me now. Your appeal, there's still the prosecutor to make her constitutional arguments. So we've had you're appealing both your conviction on the charges, and there is also the Charter of Human Rights and Responsibility Victoria's, and also the constitutional matter. So there's 3 separate elements to this appeal.
Yeah, and I think we're most likely to get a victory on the first element. That is my intention, and that's what I've been charged with, essentially, my intention. Not with any of the conduct I engaged in specifically, but what my intent was when I engaged in the conduct. And that's going to be the easiest one to win, in my opinion. The other two, it's very up in the air, because as Tim said, there's no right to freedom of expression or free speech or anything in Australia, not implicitly. It's like it has to be argued, and as you said, it's a restriction on legislation. It's easier to say that it wasn't my intent to incite ridicule of Muslims than for me to say it's my right to freely ridicule Muslims in Australia because I have free speech. So I think it's demonstrated that I'm more likely to win on the first point, because after I was cross-examined by the state prosecutor, she asked the judge to not listen to anything I said, not believe anything he said, and that nothing I said matters, which indicates that everything I said was good for my defence. Okay, so if the judge finds me guilty tomorrow, what he's essentially saying is he thinks I'm lying. He thinks everything I said in the witness box is a lie, mostly everything, and that I'm guilty because I got up in the morning and intended to go incite ridicule and revulsion and contempt of Muslim people, and that's all there is to it. We could still win on the constitutional matter and the Charter of Rights matter after that. The legislation could be limited, restricted, reformed in some way in order to grant some freedom of political discourse as a result of this case, but I don't think that's likely at this stage. I think it's much more likely that I'll win on the on the first matter of intent. However, the law is against me. The law is against us all as regular working Australians, and it has been since 1992, and that's important to understand. The Racial and Religious Tolerance Act essentially has written in it that diversity is our strength in Australia, that multiculturalism makes Australian society stronger, and it's important for all persons to be able to participate equally, and yada yada yada, okay? It uses that nice kind of language to disguise its true purpose, okay? Its true purpose, in my view, was to deracinate traditional Australia and to essentially ethnically replace Australians by any and all means. And that's been the physical result if you just pay attention to what's happening around you. So when you hear politicians and activists of any kind, bureaucrats in the media or governments say that diversity is our greatest strength in Australia, that's not just a political slogan, it's the fucking law. And I've found that out by going through this process, my appeal process. Diversity is not just a state propaganda slogan, it's not just a dogmatic piece of dogmatic opinion of some politician. It's legislated into law and has been since 1992. And there's been various amendments to it to make it worse, worse and worse ever since. Now, if you think about it, 1992 was how long ago?
27 years ago.
27 years ago, which is more than enough time to educate a single generation of students in the schools, right? Now, this is relevant because in the Racial and Religious Tolerance Act, it says, plain and simple, the primary purpose for this piece of legislation is not legal, but educational. That means that the purpose of the Act from the beginning, the purpose of the bill, was not to provide legal protection for people, minority groups who feel they've been vilified or the victim of racist attack or anything like that. The primary purpose was a brainwashing process. That's what it was for. It was for schools, it was for television, it was for a cultural application. And that was 27 years ago. And what's been the result? Well, coincidentally, now we have a new generation of young adults running around calling themselves transsexuals, Marxists, feminists, homosexuals, and all different types of various types of new identities and that kind of thing. And that's, in my view, been a direct result of this piece of legislation, which disguises itself as a nice humanitarian thing that the community needed. But that's not what it was from the beginning. And it's been interesting engaging in this whole process because that's been made irrefutable to me. It's sort of been brought to my attention and I never knew it. So,
well, I'm going to bring it back from that overall, your hypothesis of what you just said then, is that their interpretation, the Victorian government who passed it, is that they respect free speech. But what they've accused you of through this beheading study is that and it's the whole video itself, because there's the music over, there's you marching, and there's also the driving open with the car, and I can see this myself, that lay people see it, is that could scare, intimidate or threaten people from engaging in their free expression. So if they're arguing that video that will discourage people, whether fairly or unfairly, from participating in their own free expression and in the democratic process, because again, this freedom of political communication is about responsible and representative government. It's not about free speech absolutists. So what do you say to that?
So a video of me mocking an illegal act of beheading people and marching down the street with flags, in the view of the prosecution, from their point of view, intimidated other people from engaging in political process. I don't agree with that. I think the main class of people, a group of people who have been intimidated from engaging in political process, are working, voting, white Australian people who are concerned with the future of their country and are particularly concerned with what they view as the destruction of traditional Australia. We've been the subject of ridicule and intimidation. Like, I can't see how, this is something I've found that's, it's consistent with all of the accusations against me. Whatever I'm accused of is generally what the accuser is doing to me. So I'm accused of intimidating people into silence by the prosecution. Is that what you're saying?
That you've intimidated people, but you're arguing that it's your followers who've been intimidated.
Yeah, absolutely. And if I were a regular person who was less concerned with personal consequence, I probably should have been intimidated too, but I wasn't, and that's why I'm still at court. I mean, I was expected to just wear this charge and be intimidated into silence along with my other colleagues, but obviously it didn't work on me. But I don't understand how mocking an illegal act, beheading people, and then marching down the street with flags should be regarded as criminal because it's going to scare other people. It doesn't make sense to me.
Now, of course, it all comes down to, we've talked about the Charter of Rights and the constitutional matter. It all comes down to, this is what the legislation says, intent, which is basically they've got to get into your mind. And this is the first time this part of the legislation has been used because it's a criminal provision, which you could go to jail for 6 months.
Yeah.
And it's interesting to me that they're wanting to amend this act now. Fiona Patton's introduced the Racial and Religious Tolerance Amendment, which is getting rid of this intent because it was quite a vigorous cross-examination by the state prosecutor where she tried to put it to you that you must have known your intent and the reaction that you wanted. You've claimed that it wasn't about Muslims and the mosque, it was all about local government corruption.
Yeah, it was about local government corruption and also about a specific type of Muslim extremism, obviously, like beheading people. But the state prosecutor, during my cross-examination, wanted me to say what she wanted me to say. And she continued to ask me the same question in different forms to try to get me to say what she wanted me to say. And because I wouldn't say it, she then asked the judge to not listen to anything I said. Don't believe anything he says, Your Honour, it doesn't matter, But she also accused me of being evasive. But realistically, I was answering the questions as honestly as I could. The state prosecution is trying to, together with the Attorney General's office, they're trying to oversimplify the entire matter to say that Muslims are one class of people and that by staging a mock beheading in order to criticise whether it was local government corruption at the time of the building of the mosque or that particular extremist Islamic practice, that is ridiculing and inciting contempt and revulsion of all Muslim people, regardless of what different sects and factions of Muslims believe, okay? I've put it to the prosecution that not all Muslim people are the same, and to conflate all Muslim people with the act of beheading is wrong, and that's not what I was doing. They've turned around and said that is what you're doing, and that nothing you say to the contrary matters. So they want me to have basically gone out to incite ridicule and revulsion. They want that to have been my sole intent, and they want to help the judge to understand that that was my sole intent, regardless of anything that I say, okay? So in order for the judge to rule in the prosecution's favour tomorrow, the judge would need to basically be saying, I believe that Mr. Cottrell, I believe that you're lying, I believe that everything you said in the witness box was a lie, and that the prosecution is correct in everything that they have told me that you think, okay? So the prosecution claims to have gone inside my mind based on the evidence that they've put on television inside the court, the mock beheading, and they claimed to have known my intent and proven my intent regardless of me saying it wasn't my intent. So the prosecution needs to prove beyond reasonable doubt I'm a liar, and that's pretty hard to do. Like they've got their work cut out for them there, but I think they believe that they've got it. And because the law is essentially always against people like me, because that's just the way it is in the current state of subverted culture, I think it's more likely the judge will rule in their favour at this stage. But like I said, regardless, I'm still glad that I engaged in the process generally because I've learned a lot from it.
Well, I think everybody who's been in the gallery and observed the case, it's been at least quite educational about what our rights are in Victoria and Australia. Obviously, proceedings will wrap up tomorrow. We don't know whether we'll get a decision then, but yes, it'll certainly be. This might not be the end. We still don't know. Obviously, you're most confident on the actual charge, but there could still be more to come because there's a lot riding on this for the state and the prosecution.
Yeah, well, it's going to be, look, they've got a lot more to lose than I do. I mean, they've got 5 different lawyers and I've just got a barrister and that's it. They've basically pulled out all the stops on this, and there's been tremendous amount of resources on the part of the state in trying to prosecute me here. they've directed an expert witness, an epidemiologist and social scientist, to produce a very lengthy report about why he thinks the law I've been charged with is necessary and applicable and a valid law. And it's a very long-winded and complex document. But he was cross-examined today as well, and I won't get into that specifically, but yeah, it's going to be very embarrassing for the state if they lose this. I expect them to win it because just purely the amount of fucking effort they've put into it, and also because the law is strictly against me. But there's still a possibility that the judge could rule in my favour, and if that does happen, it will be very embarrassing for the government.
Well, I'll leave it there for now, given that it is peak hour here in Melbourne.
Yeah.
There's a whole lot more I want to ask you, but I'll do it another time. So
Yeah,
thanks
cool.
for your time.
Thanks, mate. Cheers.
This is WilmsFront, brought to you by theunshackled.net.
There you go, and we are expecting at least the case to wrap up tomorrow. We don't know, can't say with any certainty when the judge will make his decision. That will obviously be revealed in due course. Now, I just want to go to, because basically, as I've said, this has been an educational experience for everyone who's been in the courtroom, for myself, Blair, and also the Bendigo faithful as well, that we do not have free speech in this country. We've never had a American-style First Amendment to free speech, free press, free assembly. And it was interesting going over the Victorian Charter of Human Rights and Responsibilities, and it mixes a whole bunch of what are called negative rights, is that the government can't make legislation to impinge upon that, with positive rights, that the government needs to protect citizens, offer citizens certain protections. That is what a positive right is, while the US Bill of Rights, it's all about negative rights, what this state cannot do, which is the best way that a Bill of Rights or Charter of Rights can be constructed, in that it places limits on what the state can do. But where did this, because we don't have it's called an implied right to freedom of political communication, which means that it's not actually in the Constitution. So where did it come from? It came from a High Court decision way back in 1992. There were two cases: Nationwide News Proprietary Limited versus Wills, and Australian Capital Television Proprietary Limited versus the Commonwealth. This is when the Keating government decided to restrict what political advertising could be broadcast, and this is when the High Court said that there's an implied right to freedom of political communication. Because in the Constitution it says that Australia needs to have responsible and representative government. So that was interpreted as you cannot limit political communication if you want a responsible and representative government. That was the High Court's interpretation. So there's no explicit right to freedom of political communication, and there's definitely no implied right to free speech, absolute free speech. We will never get absolute free speech in Australia, and we probably would never get a constitutional amendment up which would absolutely defend free speech like it does in the United States. It's basically too late for that. In Australia, our only hope is repealing such laws which prohibit free speech. And of course, the Victorian Racial and Religious Tolerance Act, that is only one restriction on free speach in Australia. Of course, at the federal level, we have the Racial Discrimination Act, which 18C, which made it unlawful to offend, insult, intimidate, humiliate a person on the basis of race. The most famous victim of that law was columnist and TV host Andrew Bolt, when he questioned the Aboriginality of certain Aboriginal public activists and academics. That decision was brought down in 2011 or 2012, it was during when Julia Gillard was Prime Minister. That's what I remember at the time. The Institute of Public Affairs, they gave that case, or the argument for Bolt's defence, a lot of publicity, and they launched their Repeal 18C campaign, which was not successful in having the Abbott or Turnbull governments try to repeal it, and I don't think the Morrison government at all has any indications that they want to repeal it. On the contrary, they want to introduce another discrimination act, the Religious Discrimination Act. This is supposedly to protect religious beliefs after the legalization of same-sex marriage, but as I've warned and others have, this is a backdoor to federal blasphemy laws. And who do blasphemy laws benefit in the 21st century? It's primarily Muslims, not Christian bakers or employees like Israel Folau. And we saw the National Council of Imams. They basically said they want this Religious Discrimination Act to outlaw Islamophobia, whatever that means, which I don't know, because this is the interesting thing about the case, is that Blair is charged with, or he was convicted of ridiculing, revulsion, and contempt for a whole class of people, namely Muslims, even though he was only mocking the most extreme element of the tenet of Islam, which there are a lot of Muslims who disagree and find it barbaric, the practice of beheading. Obviously it happens in nations such as Saudi Arabia, which practice Sharia law, but it's no way a universally shared value of Islam. And so it's, as I said, this is where it sort of gets a bit grey here, that they were mocking Islamic extremism, even though they didn't say that in the video. But I'm getting bogged down here. But of course, beheading is illegal in Australia, and everyone who is a law-abiding person believes that beheading is barbaric and it shouldn't occur to anybody, especially somebody who's got the wrong religious belief, or an enemy of the caliphate, as the Islamic State used to do in 2014. So that's the sort of interesting aspect of the beheading video and the charge of religious vilification. But as I mentioned, Blair is... they have proved Blair's intent, that he intended to incite this hatred, vilification against Muslims, which, as Blair has stated, they were protesting the construction of the mosque. He says was about local government corruption and those who sought to benefit from the construction of the mosque. And it's interesting that Fiona Patten, the Reason Party MLC in the Upper House, formerly the leader and founder of the Australian Sex Party, she's proposed a racial and religious tolerance amendment, which would extend the attributes to gender identity, sexual orientation, and disability, and it would remove the need to prove intent, as has needed to be proved in Blair's case, that the vilification itself would be likely to incite these reaction. It doesn't need to be the intent. And it would keep for the serious vilification the 6 months imprisonment term. To my knowledge, that's been handballed to a government-dominated committee in the state's lower house, so it'll probably pass in some form. But Racial and Religious Tolerance Act under Premier Daniel Andrews, it's here to stay, and will have a whole number of characteristics as well. But you notice when I questioned Blair about the beheading video itself, because it's the intention, and this was in the back when they passed the Racial and Religious Tolerance Act, the intention was to only prosecute the most revolting examples of vilification, which obviously, and if you've seen this video, it was played in court multiple times, and as I said myself, the normal person in the current 2019 year would feel quite, as I said, threatened, scared, or intimidated. I'm not saying that that's justified or what they intended, but people get quite scared and intimidated by lots of things these days in the current year. But yes, I think that wraps up all I wanted to say about this matter tonight. But the takeaway is, no matter what happens, is no free speech in Australia. A lot of restrictions on free speech can easily be passed in Australia if they so like. I'll just check over in Entropy before I wrap up. I'll put the link in final time. We've got Paulie, you're a stooge, Felzoni, who's asked, was there any noise in the courtroom today? Well, I did sneeze, so yes, there was noise, but not this disturbance as the AAP reported on Monday. So no, it was just my sneeze that I think was the loudest thing in the court. But yes, that's it from me tonight. I'll be back with WilmsFront on Friday night at the normal time, 7 p.m. Melbourne time. Now, keep watching now, because Dia Beltran, she is about to have her weekly live stream, which is starting at the later time of 8:30 p.m. Melbourne time over on her channel, because, as you know, last week we crossed over into each other's shows, which split our audience, because there's a lot of people who watch my show and then go and watch her show, but obviously we don't want to have a dog-eat-dog situation, so Dee agreed to move her live events to 8:30 p.m. Melbourne time on Wednesday. She's got James Fox Higgins as her special guest, which of course he is the operator of the Rational Rise YouTube channel, writes on rationalrise.com, and is the creator of rationalrise.tv, which is the self-hosted free speech video platform, which is not just for his content, but XYZ, Maddie's Modern Life, and of course Unshackled and Uncuckables content as well, which James Fox Higgins is a co-host of as well. It was actually through James Fox Higgins' first appearance on Dia's channel that I first learnt who Dia was. That was my introduction, because James shared it on his then Facebook profile that he'd appeared on the show, and I was like, oh, interesting, there's this woman in the Australian alt media scene I'd never heard of until my friend James interviewed him. I've known James probably since the beginning when I created the Unshackled. We both sort of started at the same time. This was when it was called The Rational Right, and James did it as a collab with his friends Rob and Sven. Rob has left Rational Rise, but Sven, he occasionally appears on James Fox Higgins' live stream. Me and James have sort of been on the same journey. Back when I first met James, he was an atheist, which a lot has changed since then. I'm still an atheist, so I'm talking about just changing in our philosophy, and just how we've sort of woken up to how much the world rapidly is changing, and the motivations behind it, and the lack of challenge of it. And the Uncuckables, of course, the centerpiece of the Australian alt media lineup, will be on tomorrow night at the special earlier time of 8 p.m. Melbourne time, because we're going to spend the first hour destroying Ben Shapiro's speech at Stanford University last Thursday night against the Gropers, led by their Lieutenant America First host Nick Fuentes, or as Ben Shapiro calls them, the alt-right 2.0, and who he says are equally despicable as the far left. Nick Fuentes did his own reaction video to it, but me and James Fox Higgins is going to join me for the first hour to do that, where obviously our pull apart won't be as good as Nick Fuentes, but we certainly have a lot to pick apart ourselves about Ben Shapiro's address. And of course, the Uncockables will give another Groyper update where the Groypers, they managed to humiliate Charlie Kirk because he could not control the event with Donald Trump Jr. promoting his book Triggered with his new girlfriend, former Fox News host Kimberly Guilfoyle, who insulted the Groypers, claiming that they can't get laid, which is a stupid assertion which leftists are likely to make. Of course, please follow me on social media. I'm on facebook.com/WilmsFront. I'm on twitter.com/WilmsFront, minds.com/TimWilms, and gab.com/TimWilms. Check out the archive of WilmsFront episodes at timwilms.com, where you can also subscribe to the podcast version of your show on your favorite podcasting platforms, whether it be Apple or Spotify. The link is there, and it will show up on any of your favorite podcasting platforms. And of course, keep checking out theunshackled.net on a regular basis when the decision is handed down or a decision is reserved. I've got about 5 pages worth of notes that I've made over the past 3 days, so I tend to sit down at some stage when I haven't got other stuff to do and do a thorough breakdown of basically how, or written a report on how the case transpired, because it is truly just fascinating from a legal and Australian human rights point of view. And of course, as I keep mentioning, I haven't had a chance to edit them myself. New episodes of the Report from Tiger Mountain with Richard Wollstonecroft will be released. My colleague Steele Archer is also broadcasting live detonation episodes most weekday mornings on his dedicated YouTube channel, and also he's got his new website, steelearcher.com. And of course, make sure you check out the latest episode of Trans Tasman Talk, which is at 7 p.m. Melbourne time every Tuesday evening on the Unshackled YouTube channel. So you can go over to there and check out the live replay. Of course, it's the weekly discussion with my colleague Due de Boer from the Unshackled's New Zealand affiliate Right Minds NZ. And of course, don't forget that the RationalRise.tv has all of this content backed up. So if YouTube ever pulls the plug, James on his channel is still producing occasional content, but he plans to get back into full-time daily shows next year. And of course, keep checking out Maddie's Modern Life channel for his latest vlogs. And of course, Maddie Rose Live for the XYZ Live every Monday night at 9 p.m. Melbourne time. So a lot happening this week. I'm pretty exhausted. After last night's Trans Tasman Talk, the first thing I'm going to do after this is to have a bite to eat. So head over to Zia Beltran's channel there to check out her discussion with James, and I'll see you tomorrow night for the Uncockables and another WilmsFront on Friday evening.
Thanks for tuning in to WilmsFront. Visit timwilms.com or Rational Rise TV to view the archive of episodes. And keep visiting theunshackled.net to view all our shows, and to keep up with the latest real news and analysis.